Thank you everyone for coming along. My name is Paul Jordan. Everyone calls me PJ. That's my personal brand. And it's nice to see so many people again for trademarks, designs, and copyright of the year. Those that have been here before will know that what we try and tease out is some of the leading cases in that particular area, just to give you a good understanding when you're back, within your offices, and there are no blind spots on some of the bigger cases. So that's what we're going to try and cover today. We're going to break the session into two parts. The first part covering some trademark cases, and then the second part, as you can see, we're going to focus on designs and copyright. You'll be pleased to know, those again that have been here in the past, that no partners will be speaking this evening, apart from myself, and that will be brief. We're going to showcase the talent within the group, and we're very proud of all these people who have written on a number of these cases, and that's why they're also going to present them to you this evening. So without further ado, I would like to introduce you to Sarah Haslane, Senior Associate in the team, and she'll be talking to you about the Audi case. Over to you, Sarah.
Thank you, PJ. Good evening, everyone. I'm going to start with spare parts tonight. So this is a preliminary reference which was issued by the Court of Justice of the EU in January 24 about the four-ring logo from the renowned car manufacturer Audi. The facts can be summarized as follows. Audi, who is the renowned car manufacturer and the claimant in that case, is the owner of the EU trademark for the logo that you can see at the bottom of the slide in relation to vehicles and spare parts. GQ is an individual who was manufacturing and offering for sale spare parts, grills, radiator grills for vehicles, which included an element reproducing the shape of the Audi logo. Audi was not happy about that use and decided to issue proceedings against this individual in front of the Regional Court of Warsaw in Poland for trademark infringement. Audi was arguing that this shape was actually reproducing the Audi logo and constituted unauthorized use of that logo. Audi was relying on all the head of infringement, identical sign in relation to identical goods, similar sign in relation to similar goods and likelihood of confusion. And Audi was also relying on the reputation of the mark. GQ was claiming that a trademark owner cannot prevent the use of any use of any trademark. His action was aligned with the common practice in the industry, where manufacturers allow the sale of replacement grills that can accommodate an emblem of a car manufacturer. The exception GQ was relying on is Article 14 1C of the EU regulations, which limits the owner rights in these terms. An EU trademark shall not entitle the owner to prohibit a third party from using, in the course of trade, the EU trademark for the purpose of identifying or referring to goods as those of the owner of that trademark, in particular where the use of that mark is necessary to indicate the intended purpose of a product, in particular as accessories or spare parts. And so GQ argued that the shaped element in that radiator grill served to identify the goods had a technical function, and the consumer wouldn't see these products as coming from Audi, but coming from him. And this shaped element was not functioning as a trademark. And therefore, the use of that mark was falling within the exception of Article 14 1C of the EU regulation. The Court of Warsaw felt that it needed a bit of guidance from the EU court to see how they can resolve that case. And so they referred 4 questions to the EU court that you have on the slide. The first one being whether the Article 14 would preclude Audi from prohibiting GQ from using a sign identical to their trademark as a mounting element in spare part radiator grills, And did it make a difference whether it was technically possible or impossible to affix the original emblem to the grill without reproducing the mark? They also asked about honest practices in industrial or commercial matters. And then there were two questions about whether a trademark included in the shape of the automotive spare part would fulfill a designation function and act as a trademark. The court decided to take the questions in reverse and started to answer questions 3 and 4. The court wanted to know whether GQ's activity could be considered as a use in the course of trade, which would have an impact on the function of a trademark. So the court considered GQ's activities and reminded us that there is no repair clause in trademark law, unlike in design law, and so trademark law applies regardless of technical function. Then the court said that in the EU regulation, there is no definition of what is use, and instead, case law confirms that it refers exclusively to active conduct on the part of a third party. Likewise, the use in the course of trade is in the context of a commercial activity intended to obtain an economic advantage. And so, when reviewing that, the court thought, you know what, GQ's activities, the fact that they are selling these radiator grills bearing the Audi logo, does constitute use of the mark in the course of trade. And the court considered that the shape elements that you have on the grill is done in such a way that if you do not have the original Audi emblem affixed on the grill, you can still see that logo, and the consumer will automatically make a connection between that logo and Audi. And so that use constitutes use of the mark in the course of trade. So the next question for the court was whether this use was liable to affect one of the functions of the trademark. So the court decided to review all the functions of the trademark and reminded us that you have a trademark which guarantee the origin of the goods and the services, and the other functions included the investment function of a trademark, the communication, advertising function, and finally guaranteeing the quality of the goods and services. And so whether the use by GQ affected any of these functions was dependent on which head of infringement was in consideration. If it was identical signs and identical goods, well, any of the function of the trademark must be affected adversely by the use and not just its essential function. If it was similar goods and or similar goods and services and similar signs, well, then it would require the essential function, which is to guarantee the origin of the goods to be affected. So after having discussed all these points and reminded us all the relevant law and case law, the court finally answered question 3 and 4 of the original Court of Warsaw and considered that actually that use is used in the course of trade, affecting one of the functions of the trademark, and is infringing Audi's logo. But because it's a preliminary reference, the court is not supposed to give a judgment about that. So they just decided that it will be for the Court of Warsaw to decide whether the logo is actually identical or similar to Audi's logo, and if the goods are either identical or similar to Audi's goods. So once the court had responded to questions 3 and 4, they had to review whether the use by GQ of that spare part was falling within the exception of Article 14 of the EU regulations. The court reminded us that the purpose of Article 14 is to enable suppliers of goods which are complementary to goods of the trademark owner to inform the public of the intended purpose of the goods which they market, or in other words, of the practical link between them. Basically, we are selling a spare part for Audi. Don't come to us if you want a spare part for Volkswagen or Peugeot. So while the use of the trademark is necessary, for that purpose, the trademark owner is not able to prevent that use. In that specific case, the court decided that that use was not necessary, and the shape of the radiator grille was motivated by the commercial aim of resembling the original logo as closely as possible. And the court decided to make a distinction. The first one was the situation in which we are, where a sign is affixed to spare parts intended to be incorporated into goods of the trademark proprietor. And the second option was a situation unlike this one, where the sign is used to indicate that the spare parts can be incorporated into the goods of the trademark owner, but without affixing the trademark on the spare parts. And so the second option falls within the exception of Article 14 of the EU regulation. The first one, like in that case, doesn't fall within that exception. So the court decided that it was irrelevant to decide whether it was technically possible or impossible to affix the original emblem to the grille without reproducing the mark. The mounting element on the spare part was capable of infringing, and Audi was therefore entitled to seek to prevent that use. But again, that will be for the Court of Warsaw to decide. So this judgment is just a very good example of how the court should educate us and give a clear explanation of the law along with a guidance how we can apply. It's also very well written, and they invite again the Court of Warsaw to decide, but they really gave their opinion in that case. And finally, it's also a good example that the repair clause that we have in design doesn't apply in trademark law. That would be it for me. I'm leaving the floor to Sean.
Hello, everybody. I am talking to you today about the Skykick case, which reached the Supreme Court in November last year. Well, the judgment came out from the Supreme Court in November last year after at least 7 years of litigation between the parties and 9 or more judgments from various courts. And I guess as a sign of how important this case might be for trademark practice generally in the UK, you can tell that from the fact that the Supreme Court gave its judgment despite the parties having reached settlement between the hearing and the judgment coming out, and actually asking the Supreme Court not to give judgment, but the Supreme Court deciding to go ahead and do so anyway. Given I've only got 10 minutes, I'm going to focus on the bad faith part of the case and what that might mean for those of you who file trademarks and those of you who enforce them. Lots of you will be familiar with the facts of this case, so I'll try to kind of set the dispute out in a nutshell very, very quickly. The claimant was Sky. The parties agreed they were a household name in the UK in relation to TV broadcasting, telephones, and broadband. Skykick launched in 2014, and they had 2 products: cloud migration product, which was to migrate emails onto the cloud, and a cloud backup service, which was to do the same for emails and for office data. Sky had trademark registrations covering lots of things, which we'll come on to, but part of their trademark registrations covered computer software, electronic mail services, and computer services for accessing and retrieving information. And so some of the trademarks were more than 5 years old, but lots of them were under 5 years old. This therefore looked like a very difficult case for Skykick to defend. But the reason that this case has occupied so much court time over the last 8 or 9 years is because Sky's trademark specifications were huge. Between the 5 trademarks, they had pretty much everything covered. So they covered 22 of the 45 niche classes. The specification of just one of the trademarks ran to 8,255 words, which is about the length of a dissertation. I put it into a kind of text-to-speech calculator, and it said that it would take about an hour to read out. And it covered lots of things, which we'll come on to, including bleach and whips. Skykick therefore brought a counterclaim for bad faith and alleged that the mark should be invalidated on the basis that Sky had no intention of using them across the full breadth of the specification. And when the case reached the High Court back in 2018, Mr. Justice Arnold, as he was then, agreed and said that there was no evidence that Sky had intended to use the trademarks, and that lack of intention to use came under kind of 3 categories. One was goods where there was just no intention at all to use. So that's things like bleach, whips, insulation. There was also things like fuel additives, and then for balance, fire extinguishers. Some categories where the description was just so broad, like computer software or telecommunications, where Sky might have had intention to use the trademark for some of those things, but just certainly not across the full breadth. And then some other marks where Sky had just covered all of the goods and services within each class in the way that they drafted their specification. So the question really that's been taking up the court's time over the last few years is, what does that lack of intention mean? Does it constitute bad faith? And what should be the impact on the trademark? And I think the case and the problem at hand is nicely summed up by this quote, which is from the Advocate General's opinion when the case was referred to the CJEU back in 2019. And he kind of pondered whether we might have reached a point in trademark law where someone like Sky could get an absolute monopoly in relation to a word, because the defendant like Skykick would have no ability to defend themselves from infringement proceedings, even though lots of the trademarks hadn't been used and never would be. And so kind of answering that question is what the courts have been doing for the last few years. Before I get to the Supreme Court judgment from last year, I just wanted to go back to the CJEU ruling from 2020, because it kind of frames what the Supreme Court did. So there were two main questions on bad faith that the CJEU considered. The first was, what conduct amounts to bad faith? And the CJ was very clear that a lack of intention to use is not on its own enough to amount to bad faith. But if you've got no intention to use a trademark and you're showing no good reason for why you've registered it, then there might be bad faith. And what will definitely be bad faith is evidence that you've applied for the trademark basically as a kind of weapon to undermine other parties or to obtain a right for purposes other than as using it as a trademark. So we'll come on to look at whether or not Sky was guilty of that. The second big question is, well, what should the consequence be of a finding of bad faith? And one of the options which was suggested to the CJEU was that a finding of bad faith should lead to the trademark being invalidated in its entirety. The CJEU said no, what should happen if you find bad faith is that you should partially invalidate it. You should kind of pare back the specification to those goods or services which the trademark owner had intended to use. And that becomes really important for kind of some of the implications for this case. So, the Supreme Court judgment finally. In short, the Supreme Court agreed that Sky had applied for its trademarks partially in bad faith, and so pared back the specifications of the goods and services which they had relied on in their claim against Skykick. So just to give you one of the examples, Sky had a registration for computer software, and that was pared back to computer software supplied as part of or in connection with any television, video recording or home entertainment apparatus or service. So it became much narrower. The reasons for why Sky was found to have acted in bad faith, I think, are very important for determining whether this is relevant to other trademark applicants and how widely this is going to be applied going forward. The reasons that the Supreme Court kind of felt that Sky had acted in bad faith were partly that the specifications were very, very, very large. And we talked about that already. In addition, Sky weren't able to give any evidence and didn't have any documents which could really justify why they'd sought such broad protection. The Supreme Court was also unimpressed, I think, by the fact that Sky, when it had brought the claim against Skykick, had relied on the full breadth of its trademark registrations and had only kind of narrowed the claim as they got towards trial, and even during trial kind of narrowed the claim even further. And then finally, the Supreme Court was also unimpressed by the fact that Sky had enforced its marks so aggressively, including in relation to some goods or services which Sky didn't really have any interest in. So a couple of the examples called out in the Supreme Court's judgment are oppositions which Sky brought against Skytron, which was being registered by somebody for vending machines, and Little Sky, which was being registered by a third party for animal skins and I think footwear. If you're thinking about the bleach and the whip still, It wouldn't be surprising. Those were untouched by this judgment, and that's really because they weren't relied on in Sky's infringement case as the case went forward. I actually looked earlier today, and those are still part of Sky's trademark registrations. They are still registered for those things, even though clearly and for a long, long time now, Sky's accepted that it's had no interest in using Sky for those things. I won't talk about infringement too much because otherwise I'll take up too much time, and the parties had settled, but the Supreme Court did say that if Skykick had kind of fought on, then they would have decided that their email migration services didn't infringe Sky's marks, but the cloud backup services did. That's, I think, really down to kind of how the case was argued, and if Sky had approached this differently from the very, very start and run different cases, they might have been able to succeed on infringement for both of those two products. What's also clear from the Supreme Court's judgment is that really parties should be relying on sections 10.2 and 10.3 if they want to take action against goods and services which are slightly outside of the scope of their protection, rather than having everything registered from the very, very start. So some practical thoughts, tips. What does this judgment mean for trademark filings? Well, to an extent, the Sky marks were a bit of an outlier. They were humongous. Few of you will have got Whips and Bleach registered. But on the other hand, I'm sure lots of people in the room will have registered computer software or telecommunications or financial services at some point. And the Skykick ruling is relevant to those. The second thing I think to say as a practical takeaway is that although this was a finding of bad faith against Sky, in some ways it's quite a pro-trademark owner decision, I think. As I mentioned, the only risk is partial invalidation. There's no real deterrent for kind of overreaching when you make your filing, because ultimately what's going to happen is you'll be paid back to what you intended to use the trademark for anyway. So other than the kind of kerfuffle in the meantime, you're not in any worse a position by kind of applying quite liberally. What do we expect to see in the future? I mean, it's going to be interesting. I expect most people will be slightly more restrained in their trademark filing practice in terms of what they file for, but I don't expect any huge change. And really that comes back to the point of there's no real deterrent. How about the practical implications for litigation and enforcement? As much as it pains me to say this, I think one of the lessons from this is that you have to litigate with care. And there was, like I said, there were two aspects of Sky's conduct post-registration of its marks, which kind of came back to bite it. One was its reliance on the full specification when it came after Skykick, and the second was its enforcement activity and quite how aggressively it had enforced its marks against third parties. So Sky kind of quite gleefully pointed to 800 positive decisions in terms of its enforcement of its marks, and the Supreme Court wasn't particularly impressed by how aggressively it had enforced those marks and the action it had taken against people who were really outside of its realm. Finally, I think we expect to see an increase in bad faith attacks, both at the registry and as part of court proceedings. And so trademark owners, I think, need to be prepared to defend those. And part of that is having documents and evidence to hand, which really explain your trademark filing strategy and why you've applied for certain things at the time you did, so that those documents are there and available for when the bad faith attack inevitably comes. If they're going to be helpful, of course. If they're not going to be helpful, then bin them. That was all I was going to say, so I will pass on to Mark.
Thanks, Sean. Hi, everyone. I'm Mark. I'm going to be talking to you about another case that I am sure you are familiar with, and that is the Court of Appeal's decision in the lookalike dispute between Thatchers and Aldi. The dispute has generated quite a lot of attention. The first instance decision was quite heavily criticised for failing to offer sufficient protection to trademark owners and brands against lookalike products. But the Court of Appeal's decision, in contrast, has been lauded as a victory for Thatchers and for brand owners more generally. In the presentation, I'm going to focus on the Court of Appeal's decision, but before getting there, I'll quickly recap the background. and summarize the key findings from the first instance decision in the IPEC. So just to recap the background, the case concerned the appearance of Thatcher's Cloudy Lemon Cider and Aldi's Taurus Lemon Cider. On the left of the slide there, you can see the trademark registration for Thatcher's cider label. And on the right-hand side of the slide are images of Aldi's Taurus can and the kind of related packaging. Shortly after Aldi launched its Taurus product, Thatchers issued proceedings in the Intellectual Property Enterprise Court, otherwise known as the IPEC, for trademark infringement and passing off. Thatchers argued that the similarity of Aldi's packaging gave rise to a likelihood of confusion under Section 10.2 of the Trademarks Act and took unfair advantage of and caused detriment to the repute of Thatcher's trademark under Section 10.3 of the Trademarks Act. They also argued unlawful passing off. Aldi accepted that it had actually benchmarked its Taurus product against Thatcher's product in terms of the flavours, the ingredients, but also the kind of look and feel of the packaging. However, it denied any infringement or passing off. So at first instance, the IPEC rejected all of Thatcher's claims for trademark infringement and passing off. The key findings made by the court are set out on the slide. I'm not going to cover the Section 10.2 or the passing off findings in any real detail because those findings were not appealed. And also in the context of kind of lookalike or copycat cases, it's not unusual for likelihood of confusion and passing off claims to fail. The key points to note relate to the Section 10.3 claim, in particular the unfair advantage claim. The IPEC essentially held that Aldi's packaging had a low degree of similarity compared to Thatcher's mark, and that was because the dominant elements of the mark and the sign were the brand names and they were dissimilar. And the similar elements were attributable to descriptive, ubiquitous, and kind of commonplace elements. So the colorways, the use of decorative lemon imagery, and descriptive text appearing on the packaging. Despite even having said that, despite accepting that Thatcher's trademark had a reputation in the UK and enhanced distinctive character, and that Aldi's packaging would create a link to Thatcher's trademark, the IPEC held that Aldi's packaging did not take unfair advantage of or cause detriment to the repute of Thatcher's trademark registration. Thatcher's appealed to the Court of Appeal, specifically on the Section 10.3 claim, on both the unfair advantage side and the tarnishment or detriment side. I'm not going to focus too much on the tarnishment argument because that appeal failed and the Court of Appeal upheld the finding at first instance. Thatcher's appealed the unfair advantage part of the Section 10.3 claim on no less than 10 independent grounds of appeal. Lord Justice Arnold gave the leading judgment in the Court of Appeal, and although he did not accept all of Thatcher's grounds of appeal, he did accept that the IPEC's decision on Section 10.3 was flawed in several respects. For example, the court held that when assessing the similarity of Aldi's packaging, the IPEC was wrong to only compare the kind of 2D representation of Thatcher's trademark against Aldi's three-dimensional can. And that issue arose due to a quirk in the way that Thatcher's had pleaded its case, but the Court of Appeal said that the IPEC ought to have considered how the mark was used in reality and how it was applied to Thatcher's can. And had it done that, it would have held that the marks were similar to a higher degree than the IPEC held. The IPEC also failed to properly consider Aldi's intention when it came to assessing the Section 10.3 unfair advantage claim, because the IPEC judge limited its assessment to whether Aldi had intended to confuse or deceive consumers. And that is a question which is relevant to the Section 10.2 likelihood of confusion claim, rather than whether Aldi had intended to create a link and or take unfair advantage of Thatcher's trademark, which is the relevant assessment when it comes to Section 10.3. Lastly, and perhaps most notably, the IPEC was held to have completely failed to consider Thatcher's argument that Aldi's packaging had resulted in a transfer of image from Thatcher's trademark to Aldi's own product, effectively riding on the attractive force of Thatcher's trademark. In light of those flaws, the Court of Appeal effectively reconsidered the unfair advantage claim under Section 10.3 and concluded that Aldi's packaging did result in a transfer of image from Thatcher's trademark and took unfair advantage of the reputation of Thatcher's mark. The key factors underpinning the Court of Appeal's decision are set out on the slide there, and I'll just kind of pick up on a couple of those. The Court of Appeal did confirm the IPEC's finding that Thatcher's trademark had a reputation, and that, in light of the slightly heightened degree of similarity of Aldi's packaging, that the packaging would create a link to Thatcher's trademark. Unlike the IPEC, the Court of Appeal held that Aldi had actually intended their packaging to remind consumers of Thatcher's product and intended to create a link to convey that Thatcher's product was effectively that Aldi's product was a cheaper version of Thatcher's product. And the court also noted that there was social media evidence of kind of consumers' reactions to the products and comparing the products, which supported the link that had been created, and that Aldi's message had kind of been received pretty loud and clear. Also, Aldi had been able to basically sell its product in really significant volumes in a relatively short space of time with almost zero marketing and promotion. In the absence of any proper explanation for the success of its product, or that Aldi would have achieved equivalent sales had it not resembled Thatcher's products, the Court of Appeal held that it was reasonable to infer that Aldi had taken unfair advantage of Thatcher's reputation and had effectively ridden on the coattails of that reputation to facilitate the sale of its own products, and that it had not competed fairly based on the product characteristics or its own marketing or advertising of the product. Quite interestingly, Aldi tried to rely on a defence under Section 11.2b of the Trademarks Act, based on the fact that the elements of its packaging that were similar and gave rise to the link, it argued were non-distinctive, and therefore they could rely on a defence under 11.2b. However, the Court of Appeal rejected that defence for two reasons. Primarily, first, because when you are assessing that defence, you need to look at the mark as a whole, not just specific elements of the mark or the sign. And when you looked at Aldi's packaging, it was in the round distinctive of Aldi. It wasn't non-distinctive. And also because the court held that Aldi's conduct was effectively unfair competition. And because of that, it didn't accord with honest commercial practices. So the defence under Section 11.2b was not open to Aldi. So what does this all mean, and where does it leave us in cases involving lookalike products? I've set out a few kind of practical takeaways and learnings from the decision, but I think it's important to flag before going into those that Aldi has applied for permission to appeal to the Supreme Court. The Supreme Court has not yet made a decision on whether or not to grant permission, so that's still pending. But it may be that the Court of Appeal decision is not the final word on the matter, and the Supreme Court, if it accepts permission to appeal, could reach a different conclusion. But in the meantime, we have the Court of Appeal's decision, and I think the outcome kind of underscores the value of trademark registrations and Section 10.3 claims in cases of lookalike products. ultimately, in this case, if Thatchers hadn't have had a registration for the label of their packaging, they would not have been able to succeed in preventing Aldi's sales of the product, and their infringement claim would have essentially failed. Typically, lookalike products have been able to kind of sidestep infringement by mimicking features of branded products that are typically perceived as being less distinctive, but kind of contribute to the overall look and feel of the product. So colorways or decorative imagery or descriptive text, and then combining that with a distinctive or different brand name. But in this case, the finding that Thatcher's trademark had a reputation as a whole, so for all of the elements of the figurative mark, not just the brand name itself, and the fact that the elements of Aldi's packaging created the link were those less distinctive elements, so the colorway, the image, the lemon imagery, and also the kind of descriptive text is quite an important development in terms of brand owners wanting to rely on trademark registrations, because it should really make it easier in future cases, in future 10.3 cases, to establish a higher degree of similarity, and also establishing a link between the lookalike and the trademark registration. Provided, of course, that brand owners register trademarks for their packaging and trade dress. I think it's also important to just flag that in the context of this, Section 10.3 claim, reputation is fundamental. The decision and the outcome on appeal will most likely impact highly successful brands, products that can establish a really significant reputation in the UK, and lesser known brands and products are probably unlikely to benefit from the same level of protection generally. I think the decision also kind of establishes the importance of being able to prove that reputation when it comes to proceedings. So, for example, Thatchers was able to rely on a wealth of evidence about its marketing activities, its spend, and how it had promoted the product to really ram home how significant its reputation was. More practically, I think in light of the decision, brand owners should, at the very least, be evaluating their trademark protection, at least for their most valuable products and any market-leading products that are likely to be used as potential benchmarks for the development of lookalikes. Brands that don't have registrations for packaging or trade dress should really consider applying for protection, and should consider these filings kind of as part of their broader filing strategy moving forwards, even if those trademarks are not ever enforced or relied on in proceedings against lookalikes. The fact that the mark appears on the register can act as a deterrent for third parties looking to develop lookalike products. Even though the Court of Appeal's decision may not be the end of the matter, and the Supreme Court may take on the decision, I think the brand owners and trademark owners could use the decision as impetus to take a kind of more proactive monitoring and enforcement of their products and their trademark registrations, and use the outcome in this case to try and tackle lookalike products. And lastly, on the flip side, whilst the decision is unlikely to bring an end to lookalike products and is unlikely to change the kind of general practice of benchmarking, I think the outcome on appeal does demonstrate and highlight the risks of designing your products too closely to resemble established brands or brands that are protected with trademark registrations. And it also illustrates that there is actually a very fine line between sailing close to the wind and a finding of trademark infringement. Moving forwards, I think those third parties who are in the business of developing lookalike products will need to act more vigilantly with trademark registrations, and also how closely they develop their products to kind of mimic or follow what's perceived to be the market-leading product. So that's all I had to say about Thatchers. I'll hand over to Victoria.
Thanks, Mark. This is another long-running case that I will discuss. It started in 2019, and it's a decision that started in the High Court and went all the way up to the Supreme Court, like in the Skykick case. So the decision concerns infringement, trademark infringement, in the context of basically websites. So it's quite interesting for basically website operators and trademark owners alike in terms of the implications. So in this case, I'll just briefly whiz through the background, but basically Lifestyle Equities is the owner of a number of trademarks for, you may be aware of them, Beverly Hills Polo Club. And they brought a trademark infringement claim against Amazon, who effectively, through its US website, was selling effectively branded goods under identical brands. It's slightly unusual in this case, but basically what happened is that there was a totally unrelated party, which wasn't neither Amazon or Lifestyle Equities, that actually had basically identical corresponding marks to Lifestyle Equities, but in the US. And Lifestyle Equities were happy to live with them as they would be based in the US, whereas Lifestyle Equities had rights in the UK and in the EU. So they didn't mind them, but the problem effectively arose when Amazon, from its global US website, started marketing and selling these goods from its US website into UK consumers. And obviously Lifestyle Equities was like, what the heck? You can't just do that. So they contended that sales and marketing to UK consumers from that website was effectively infringement. That's the brand. And the key issues, you may have seen the brand because there's other cases as well that basically discuss. They've been involved in less litigation. But basically the questions were twofold. Lifestyle contended that Amazon had effectively infringed by either targeting UK consumers, and therefore that meant that even though the sales effectively happened outside the UK, because they were targeting UK consumers, then that meant use in the course of trade in the UK, and that was trademark infringement. In the alternative, and this is a strange position, but I'll explain this later, the actual sales, even if they weren't preceded by effectively offers for sale or marketing to UK consumers, would have amounted to infringement anyway, because they were sales to UK consumers. Okay? So in terms of like targeting, I'm sure you're all familiar with targeting at this point, but basically targeting is a device that effectively UK and EU courts came up with to deal with cross-border infringement. So basically infringement that occurs through a website, and it may be outside the EU or outside the UK. And because that use targets consumers in the UK and the EU, even though it's abroad, then that means that that use is deemed to be used in the course of trade in the UK or the EU, right? And the position that the courts initially took was that effectively mere accessibility to a website, so a website that is globally available and that's it, it's not enough to effectively say you're targeting consumers in a specific territory, or the UK and the EU. There has to be more than that. And effectively, that more has to be effectively the intention from the website operator. This is how it started. And if the website operator could be implied from things such as the products are being sold in pounds, then you could argue that that operator is intending to target UK consumers and therefore infringing UK trademarks. The shift then moved slightly through the case law. Cases were like Palmer, L'Oreal. It moved on, Argus. And the focus shifted strictly from the operator's intention onto consumers. And I'll explain how this applies to this case, which effectively discusses all of this. So the dispute started in the High Court, as I said before. The High Court initially resolved that the Amazon global website did not target UK consumers. And the reason was because they felt that, and it feels from reading the decision, that they did focus a lot on Amazon's intention as opposed to consumers' experience. So they looked at things like, for example, the website said, well, there's the UK website available. And so as a UK consumer, you can go to the UK website. There's like cheaper prices and lower delivery fees there. So why wouldn't you go there? And there were very limited sales to UK consumers. And the High Court also felt that the only reason as to why Lifestyle was bringing this case forward was because the US branded goods were cheaper in value, and therefore that would devalue the value of their own brand in the UK. So for all of these reasons, the High Court felt that ultimately it wasn't Amazon's intention to target UK consumers, and therefore they were held not to be targeting UK consumers, and so they didn't infringe. Then Lifestyle Equities appealed to the Court of Appeals, who took an entirely different view. They basically thought that, the Court of Appeals judge thought that effectively the High Court had placed too much weight to the perception of the US website as a whole, the fact that it was a US global website, but didn't focus instead on the specific acts of infringement that were complained of. And in this particular, one of the particular things that they looked at was effectively the review your order page that you get. I'm sure you're all familiar with Amazon. But by the time you get to a product in Amazon and get to add to your bag, then you get a review your order page with the product, with the prices, with the shipping, with basically all of the details and pricing. All of these details suggested that to a UK consumer that the product would be effectively billed in pounds, delivered to your door. We'll take care of all of this, and therefore an ordinary consumer in the UK would feel that this is targeted to them. So because of this, they felt that the Court of Appeals felt that as a whole, effectively, a consumer would believe that Amazon was targeting them, and the fact that lower prices and the fact that a UK website existed alongside wasn't enough to effectively remove that. They felt that if there were cheaper prices elsewhere, a consumer wouldn't necessarily know and may not care. And the other point was you can have a website that is primarily targeting US consumers, but that doesn't mean that you can't be targeting other consumers effectively. And the other thing which is very important is that even though the subjective motives of the website operator could be taken into consideration, they're not fundamental. If the consumer felt targeted, then this is what is fundamental. It doesn't matter that even if Amazon didn't want to, you don't need to prove that Amazon wanted to target UK consumers. And that's a very important point that I'll come to. So, spoiler alert, the Supreme Court agreed with the Court of Appeals, but the reasons for them agreeing were slightly different. So again, the Supreme Court felt that just a review of specific parts of Amazon's website, like the Court of Appeals did, was effectively not appropriate. They needed to look at the whole thing. They needed to look at the impression of the website as a whole. And in fact, if you did look at the entire website, then you could see a clear journey that the consumer would take from beginning to end to then come under this impression of basically this website is targeting me. And the starting point was that you would go onto the website and you would see that sign, basically that, I don't know if you can see it from there, but basically it says, we're showing you items that ship to the United Kingdom. To see items that ship to a different country, change your delivery address. And then effectively Amazon not only had that, but also showed all items that specifically would ship to the UK. So it was very specific in terms of like the algorithm and what they would show to UK consumers. They would effectively see this, and then through their journey, they would end up in the review items and shipping page, the review order page, that effectively looked like an offer to UK consumers and effectively said, this is the billing address, UK billing address, UK prices will take care of the shipping, and you'll receive your item, in your house in the UK. And so all of that, the court felt, if you made the trip effectively forward rather than backwards, which is what the Court of Appeals did, so start from the beginning rather than from the end, all of that as a whole, the whole concept, the whole context suggested that effectively Amazon was seeking the business from UK consumers. So the other thing that the Supreme Court actually agreed with was the fact that delivery times and lower charges on the UK website were not really relevant. This didn't really point against targeting. And it's all about, effectively, the way the Supreme Court looked at this was facts that point towards targeting UK consumers and facts that don't. And that wasn't just sufficient to effectively point away from targeting. The working forwards rather than backwards, which is what I explained before, and the UK tailored element. So all in all, what the Supreme Court considered was effectively the consumer's perspective. And this is the heart of the assessment, effectively, whether a consumer in the UK would feel targeted. And this is regardless of what the intention of the operator was. Issue number 2. So this is a rather strange case, so I kind of need to explain what Bloomquist is about. But effectively, Bloomquist was a decision in the context of the customs regulation by the Court of European Justice. And the decision was given in the context of a customs, effectively, action that Rolex took against an individual in Denmark who imported for his own purposes a Rolex, which was a counterfeit. The Rolex was seized by customs. Customs asked Rolex, is this a counterfeit? Rolex said, yes, we want to destroy it. And then Bloomquist said, well, I paid for this. Why would you want to destroy my counterfeit Rolex? The case ended up effectively in the CJU with a referral from the Danish court. And effectively, what they had to decide was whether, because the circumstances of the sale weren't clear, and it wasn't clear, we believe that Mr. Bloomquist wasn't effectively targeted. The question was whether in the context of the customs regulation, you needed to show that you had targeted that consumer in order to prove that the customs regulations were engaged. And the CJU decided, well, you don't need to prove that there was targeting. You can't deprive the owner from its rights. Clearly, if the customer bought the product, it's because the sale itself targeted them. So that was the decision in the EU. Now, this was an argument made in this case where basically Lifestyle Equity said, hang on a minute, even if Amazon had not deliberately targeted UK or EU consumers, then because they've made sales to them, then they should be liable for infringement too on the basis of this decision. That basically establishes or could be interpreted as establishing strict liability just because of the sale. So the High Court said, no, the effect of that decision should be narrow. It applies only in the context of customs regulations. There's no clarity as to the ambit because we don't know. It's a very short decision. There's not that much detail on effectively what took place, where the sales took place, and all of that, which you would need. So it's a particularly obscure decision. So in the High Court's view, then this case didn't apply. Then the case went to the Court of Appeals where the judge effectively felt that the High Court was misapplying effectively the Bloomquist decision. And plainly what the decision said was that there was no requirement for their sales to be preceded by targeting. And sales effectively themselves were targeting. And as a result, therefore, there could be strict liability, there could be infringement even without targeting. So this is where I disappoint you. Because the Supreme Court decided on the issue of targeting, there was a finding on targeting. The result was yes, you targeted UK consumers and therefore you have infringed, then there was no need for them to talk about passive sales. And so they kind of like let it slip that they didn't necessarily agree with the applicability of Bloomquist to the case. And so they kind of like implied that they disagreed, but they didn't really resolve the issue. And so that is a problem for us lawyers, or well, maybe not a problem, but there's clearly like a lot of uncertainty when it comes to the application of it. As obviously we have a decision from the Court of Appeals effectively saying this applies, and a decision from the Supreme Court which suggests that it doesn't apply. So it's something to bear in mind. And the implications from this case are actually huge. And you can look at it from both ends, from the end of basically parties who want to enforce their rights, and effectively where the operator's intention may be less clear, but they might still be using their marks or your client's marks or your marks in the UK. And so you would be, on the basis of consumers' experience, be able to claim trademark infringement. You don't necessarily need to show that there was an intention to target them. So the focus now rests heavily on consumers and the overall context when it comes to the website. The counter side is you ought to be vigilant because you could be infringing without realizing by smoothing people's journey through your website and allowing them to purchase your stuff, basically. There's obviously also the risk of how this passive sales and the doctrine of Bloomquist would apply in the future, and how this will be treated by the courts. So there's also the risk of, even if you're not making your consumers' trip easy, if you're allowing them to purchase those goods, then you could still be at risk. And so we would encourage basically everyone to review their websites and consider what the risks are in that respect. But yeah, that's all from me, and I may hand you back to PJ.
If only briefly. So I'd like to say thank you to all the speakers on the trademark review of the year. So maybe you can join me in closing.